Further hearing the appeal in the King on the application of Maguire against the Majesty's Senior Coroner for Blackpool and Fylde and another.
Yes, Ms Richards.
Well, a supplemental bundle, a handful of additional materials was provided to the court last night. I'm not proposing to take the court through it unless there's anything in particular the court would wish me to do so. I hope the material in relation to this court's decision in N and a CCG, coupled with the Mental Capacity Act Code of Practice, I hope helps explain the approach to decision making and who a decision maker might be on any given occasion. You will also have Section 73 of the Care Act, as requested yesterday. My Lords, my Lady, I indicated yesterday that just 2 points I deal with this morning. There are in fact 3 I wanted to deal with. It can obviously reduce accordingly any time I have by way of reply. The point that I didn't mention yesterday is really just to take the court to one particular case we didn't look at yesterday, which in my submission is a helpful one. It's the case of Gültekin and Turkey at page 4665 of the bundle. And it's a conscript case, so not someone detained or deprived of their liberty, but someone effectively regarded as being under the control or supervision of the state by reason of being a conscript. And it was the case of someone who had hepatitis. And the issue there was about delays in transferring him to hospital over a relatively short period of time in the course of March 2004. I won't read through the facts, but they're set out in particular in paragraph 14 of the judgment on page 4667. If we pick it up on page 4669, paragraph 23, you will see the case that was advanced. The delay in transferring him to hospital from his regiment delayed his access to appropriate treatment and thus caused his death. And the argument was that because he was under the authority of the military administration, the state should be responsible, should be held responsible. And then if we turn to the court's assessment, page 4671, paragraphs 31 onwards. 31 is simply the general description of of Article 2. And then paragraph 32, in my submission, is significant. So the courts also had previous occasion to emphasise that persons deprived of their liberty, such as persons in custody, so a wider concept of deprivation of liberty than imprisonment, are in a vulnerable position and that the authorities are under a duty to protect them. This duty to protect, when read in light of the positive obligation described in the preceding paragraph, extends to protecting the health and well-being of persons deprived of their liberties and implies an obligation for the authorities to provide such persons with the medical care necessary to safeguard their life. And then
that duty to protect must, in context, be a duty under Article 2.
Yes, absolutely. And then paragraph 33, noting the salient parallels between the situation of persons in custody and conscripts during their compulsory service, the courts held that conscripts are also entirely in the hands of the state. And then paragraph 34, just picking it up in the last few lines on that page, to that end the court observed that, and if you go over the page, the applicant's relative started his military service on the 22nd of August 2003, was in the course of doing so when his health problems began. And then this is the reference I referred to yesterday but couldn't remember the case. It's not disputed that while he was performing his military service, he was not able to leave his regiment in order to procure medical treatment from a medical establishment of his choice. And then paragraph 35 makes clear the relatively narrow framing of the case, not a suggestion that his hepatitis was due to actions of the state, nor that the treatment he received once hospitalised was unsatisfactory or inadequate. Their complaint relates solely to the military authorities' failure to send him to hospital on the 17th of March, contrary to the decision of the doctor who examined that day, and their subsequent and repeated failures to take him to hospital until the 23rd of March.
So that makes it sound as though a doctor was saying to the military authorities, this man needs to go to hospital. and he was subjected to an order, no, you can't go.
It's I think, perhaps not quite as stark as that. So there was a recommendation from a doctor to transfer that wasn't followed. And then that was I think earlier, and then there were further tests undertaken. I'm not suggesting it is no case is ever factually identical to another case, but it's the general principles I seek to draw out of this: the nature of the duty to the obligation by reason of the individual being in the control, effectively, of the state.
But I mean, just in terms of the operative duty, the military authorities were told by a doctor, this person needs to go to hospital, and they refused. That's the context of this case, as I understand it.
Yes, or did not act on that recommendation. Yes.
So the emphasis here seems to be on access.
Yes.
Okay.
Yes. And then paragraph 37 articulates again the positive obligation to provide him with prompt and adequate medical treatment for his problem. And then if we go over to page 4673, paragraphs 40 and 41, here echo the Keenan-Osmond formulation, but without the stringency of real and immediate risk. So you will see in paragraph 40, court observes the military authorities were given ample indications that he might have contracted hepatitis and considers that they knew or ought to have known of the real risks to his life. And then we see the reference there to Keenan. And then paragraph 41, although the military authorities were thus aware of his health problems and should have taken measures within the scope of their powers, which judged reasonably might have been expected to protect his health, they failed to do so. And again, that echoes the language of the Osman and Keenan line of authorities. So this is a case which essentially draws together the idea of the protective duty, the protective obligation, the importance of providing adequate health care to those who can't access it for themselves, but recognises that that will arise only where there is some form of actual or constructive knowledge, hence the reference in knew or ought to have known of real risks to life.
Actually, if one were contrasting this with Osman, the implication of paragraph 32 is that the obligation to protect the health of a person in custody, who is deprived of his liberty, rather, isn't conditional on an imminent threat to life. It arises by virtue of the fact that the person is deprived of their liberty, it seems.
Yes.
And then in asking whether there's been it's a duty to protect the health of the person, and when they're looking at whether there's been a breach, in paragraph in paragraph 41, the focus in asking whether there was a breach is whether they took measures which might have been expected to protect his health. As you say, it arises on the basis of knowledge that his health was at risk.
Yes. So there won't be a breach if the authorities have no reason whatsoever to suspect that somebody might have a condition that might have serious consequences for them.
Yes, but it doesn't appear that they have to be on notice that the person might die.
No.
Well, sorry, I wonder if that is right. I mean, looking at paragraph 40, the focus seems to be on knowledge or known of real risk to his life, and then the citation of Keenan again.
Yeah. Yes, that's right.
I mean, if this is found in Article 2, one might think that you need some foundation in risk to life. But tell us if we're wrong.
This case has never been argued on behalf of Mrs. Maguire on any other basis. That the authorities have to have. There has to be some basis for thinking that there is that there may be a significant health problem that could have implications for life.
Mm-hmm.
Well, that's a much more nuanced test than what you just said is a much less stringent test than real and immediate, that they knew or ought to have known that there was a real or immediate risk to life. But do you accept that that wording is the correct wording?
The real and immediate risk to life?
That they knew or ought to have known there was a real and immediate risk to life?
Well, my lady, as I hope I indicated yesterday, we put the case in two ways.
Yes, but on the first way.
But on the first way, if you're looking at the classic formulation of the Osmond test, which is the test that this court used in Raybone, it's real and immediate risk.
Yeah, which is rather different from what you said a moment ago, no breach if the authorities have absolutely no reason to think that he's ill or the person's ill. That's a much different test.
Yeah, well, that wasn't intended as an articulation of a test.
The foundation of these incremental developments seems to be the Osmond case and the real and immediate risk. It would be surprising if the Strasbourg court was departing from that without drawing attention to the fact that it was doing so.
I accept that, Manuel. Yes. But in any event, this is a case which appears to bring together the expression of the protective obligation which we saw in cases such as Tarajeva yesterday with a formulation in slightly different terms, but not very different terms from the Osmond and Keenan approach. And the basis for it, the basis for the obligation is the individual being here not detained, but essentially under the control of the state and unable to access healthcare for themselves.
Sorry, you were referring there to Tarajeva again. I mean, I was looking at how that case was treated in Savage. That was treated as an example of the impact of a breach of the systemic duty, not of the operational duty, I think.
And my lord,
is that right?
Is correct. And in Raybone, it's treated as a case indicating breach of the operational duty.
Right. So which do you say it is?
My lord, the operational duty is how we have always read that case.
Right. So
we see the scope for viewing it differently, but certainly this court in Raybone, as I recall, seems to regard it as a breach of an operational duty, a duty owed to an individual to ensure that their health is protected by the provision of treatment to them.
And at some point, could you give us the paragraph references in Raybone?
Yes, I don't have it to hand, but I'll come back to that at the end of the day. And then the final finding in this case is just at paragraph 48, bottom of page 4674, and top of the next page, which is the conclusion that there has been a breach of Article 2.
Like a lot of these cases, this one has passages that one could read as supporting different positions. When you look at paragraph 36, they say that that establishing whether or not the delays had a bearing on the death was the duty of the national authorities, who bore the burden of providing a plausible explanation for the death of a soldier under their exclusive control. So the fact, I mean, on the face of what's said here, the fact that a soldier dies, I mean, places a burden on the national authorities to provide a plausible explanation for his death. And they ask, so then go on to say, the court will therefore establish whether the state has discharged that duty by showing that the delays did not have a direct bearing on the death, and that the national authorities did everything which could reasonably have been expected of them under the circumstances to protect the man's life. One goes on to, I think it's 48, where they're sort of reaching a conclusion. the court has stated above that what was expected, i.e. duty, from the national authorities was to do everything which could reasonably have been expected of them under the circumstances to protect the soldier's right to life. Having examined the evidence effectively, the court concludes that the government have failed to satisfy their burden of showing that the authorities complied with their positive obligation by taking timely and adequate measures in order to prevent the fatal outcome. It's a long way away from Osman.
My Lord, it may find its echo in some of the domestic case law in relation to prisoners and the procedural obligation and the automatic obligation arising, the automatic procedural obligation arising where someone dies in custody to provide an account of how that came about. I haven't sought to address this court on issues relating to arguments about burdens of proof because the approach taken in Strasbourg doesn't appear to be particularly relevant to the exercise here, which is what the coroner should have done and what should have been allowed to be left to the jury to consider. But in terms of one looks at the underlying circumstances and the way in which the court describes the exercise it carries out in paragraphs 40 and 41, it's not, in my submission, a long way from Osman and Keenan. It's melding together Osman and Keenan with the recognition of the particular protective obligation that arises to safeguard the health of those who over whom you exercise control.
It's stating the obvious, but if there is a true analogy here between the position of the soldier and the position of a resident of a care home who's been the subject of an order under Article 5 depriving them of their liberty, then this has enormous implications.
Yes. The European Court has never seen any difficulty in extending the reach of the operational obligation to conscripts. I'm very conscious of the language of Lord Roger in Savage that one shouldn't have an auction in comparative vulnerability. But the position of someone who is in Miss Maguire's position, we would submit is stronger in terms of attracting or fulfilling the criteria identified by Lord Dyson in Raybone as essential to the iteration and development of the Article 2 obligation, because it's deprivation of liberty, which the conscript cases are not, and vulnerability in a way in which is perhaps a more substantial vulnerability than certainly the position of the average conscript will be. Here, the vulnerability that's identified really appears to arise only because of the inability of the conscript to access care for themselves because they're doing military service. Whereas in the case of someone such as Miss Maguire, the vulnerabilities are obviously more multidimensional, as I indicated at the outset of my submissions yesterday. But this is, in my submission, a faithful application of the pre-existing principles and wholly consistent with Lopez de Sousa Fernandez because of paragraph 163 of that case. In any event, that's the authority that it seemed to me important to draw to the court's attention. Can I then turn to the two matters I said I'd deal with yesterday, the Court of Appeal's judgment, in particular its reliance on the case of Dumpy, and then the question of essentially remedy and a further inquest. So in terms of the Court of Appeal's judgment, we've addressed that judgment in the last part of our written case, and I'll take what we've said there as read without going through it. But our criticisms of the Court of Appeal's judgment essentially flow from the case law that I've been addressing the court on. And then if I can make the following further short points by way of summary of where we say the Court of Appeal went wrong. We say the court failed to recognise that the present case is on a par with Savage and Raybone, and wrongly saw this as a Lopez de Sousa Fernandez case. And the Court of Appeal brushed over the significance of paragraph 163 of Lopez de Sousa Fernandez in paragraph 99 of their judgment at the end, where they say it doesn't affect the outcome in a case of this sort. That's the first point. Second point, in paragraph 97 of their judgment, the Court of Appeal found that the operational duty can't arise for someone in a care home in the event of a death following failures by medical professionals, but only in the event of ill treatment or neglect of the kind set out in the Nencheva case. Those were the children in the Bulgarian home over the 1996-1997 harsh winter, or the Campianu case, that's the young man with HIV.
Which paragraph is that?
That's paragraph 97 of the Court of Appeal's judgment. And we say that's an error because it introduces a threshold which doesn't apply to prisoners or immigration detainees or the detained psychiatric patient or the voluntary patient or the conscript, but does apparently apply if you're deprived of your liberty in a care home. That is Lord Rogers' unedifying auction in comparative vulnerability, in my respectful submission, a lesser degree of protection, with no justification for that in the authorities. The fourth point, my lords, my lady.
But are you saying that the Court of Appeal was suggesting that if exactly the same things had happened to Miss Maguire or to somebody who was actually a prisoner, that the Court of Appeal was saying that there would be an arguable breach of Article 2?
That is how I read their judgment, my lady, yes.
I'm not sure how you do get that out of... I thought the Court of Appeal was actually quite careful to say that there would be situations which would be equivalent for a prisoner. For instance, if a prisoner fell ill and had to be taken to a hospital or whatever, where the situation would be the same, that it would be the same standards as the Court of Appeal applied in this case.
So if you have the pure natural causes case of a prisoner, and the authority there, I think, is the case of Tyrrell, then, my lord, that's correct. But if we read through and see the discussion in relation to dumping, and I'll come back to why I say that's wrong. In my respectful submission, they are saying that there is a lesser duty to those who are in a care home and whose death results or arguably results from failures of medical treatment. They must be saying that because they essentially say this isn't a Raybone case. Whereas we say it is exactly the kind of situation covered by this court's decision in Raybone. And paragraph 99, we say wrongly, that to hold an operational duty was engaged in this case would be to move beyond any jurisprudence of the Strasbourg court and wouldn't flow naturally from existing Strasbourg jurisprudence, as the conclusion in Raybone did. So they say it's essentially analogous to the situation of a death from natural causes with no suspicion of fault on the part of the prison authorities in prisons. My lady, and just before I come to Dumpé, then just two observations about paragraph 102 of the Court of Appeal's judgment.
Paragraph
102.
Thank you.
The suggestion there, halfway through that paragraph, is that if Ms Maguire needed medical treatment, it was sought in the usual way from the NHS, and the assertion that she was not in the care home for medical treatment. Whilst it's obviously correct that she wasn't in the care home to be treated medically in the care home because it's a care home and the carers are not medically qualified, they're not healthcare professionals. I showed you yesterday at the outset, or gave you the reference yesterday at the outset of the hearing, to the deprivation of liberty safeguards form, which identified as one of the reasons why it was in her best interests to be in the care home, was that access to NHS care could be arranged for her, she being someone who cannot arrange it for herself. The suggestion that she's just someone analogous to anyone in the community, effectively, who can seek treatment from the NHS in the usual way, ignores everything that went wrong in the case and everything about her particular circumstances, which showed that as a vulnerable person with learning disabilities in the care of the state, she couldn't seek care in the usual way from the NHS. She was wholly dependent on others. And so it's paragraph 101 I should have referred to rather than paragraph 102 there. And then paragraph 102, the reference there is, they say they don't have to decide real and immediate risks because they're concluding on the law about duties, and the Osmond test isn't the applicable test. But they then say if you are going to look at that, you use the relatively light touch approach compared with those detained by the state in prison or involuntary psychiatric patients, articulated by the Strasbourg Court in Fernandez de Oliveira. Leaving aside the idea of a relatively light touch approach and the appropriateness of that in the context of care and for the vulnerable, they have missed the point here that Fernandez de Oliveira was a case of a voluntary patient, not somebody deprived of their liberty.
Well, the light touch, doesn't that just apply to the question as whether they've done everything they reasonably could have done to prevent the risk from materialising?
No.
Or does it apply to both?
Here,
in the Court of Appeals.
In the Court of Appeal appears to be applying it to the question, to both questions. Because they say in determining that question, the relatively light touch approach, and the question has, in the previous sentence, brings together both those elements. So that's how I read it. But in any event, firstly, Fernandez de Oliveira is not the authority in this context, because that's about someone who's not deprived of their liberty. Ms Maguire was deprived of her liberty, and therefore, if one is going to have comparisons, the comparison should be with those detained by the state in prison or the involuntary psychiatric patient. Secondly, and in any event, the Court of Appeal was bound by this court's decision in Raybone. In the case of a voluntary psychiatric patient, no suggestion by Lord Dyson, Lady Hale or the remainder of the court that you have a light touch approach or that anything other than the normal approach is taken. The final point then, but important point in relation to the Court of Appeal's judgment that I should deal with is their reliance upon the case of Dumpe, which is relied upon at various parts of the judgment. You have written submissions on that in our case at paragraphs 65 to 67, and then in the interveners' cases, Mind has addressed the case of Dumpe in paragraph 11D of its submissions, and the Equality and Human Rights Commission has addressed Dumpe in paragraphs 31 to 36 of its submissions, and I adopt without repeating what's set out there. Dumpe appears at page 2618 of the bundle, but the submissions I propose to make don't require you to look at the case itself, but I'm obviously entirely up to the court whether it does so. But really 4 short points about Dumpe. Firstly, it was an admissibility decision focused on the question of exhaustion of domestic remedies. But that's the issue that's explored in the body of the judgment from paragraphs 49 onwards. Had the applicant exhausted criminal or civil remedies available to her within Latvia, and they found that she had not. Secondly, in Dumpe, no argument was advanced by the applicant of any systemic breach or of any exceptionality argument. So the applicant didn't seek to fit the case within Lopez or argue a systemic breach more generally. Thirdly, in the decision, there's no discussion of the operational duty at all. And fourthly, there's no discussion of paragraph 163 in Lopez de Sousa Fernandez and its implications. So it's not a case which advances understanding of the legal principles and their application. It really is a case all about the exhaustion of domestic remedies, in which the underlying obligations.
Well, you say that, but it contains quite a lot of significant dicta, and it's a, it was a chamber which included some very respected judges. They distinguished the Campianu case as one where the state was aware of appalling conditions, which is interesting, and they distinguished cases concerned with failure to provide a detained individual with emergency medical care necessary to safeguard his life, which is essentially an Osman type of situation, but in relation to a detained individual. And they referred to the very exceptional circumstances in which the responsibility of the state may be engaged under the substantive limb of Article 2. So they're not suggesting that it's a sort of routine duty, even in relation to detained people.
Well, the issue of detention is not in itself examined in the case at all.
2618 it starts.
It's very much tailored, a judgment tailored to the way in which the case was advanced on part of the applicant, perfectly understandably. And we see from paragraph 58 on page 2631, the applicant didn't argue systemic breach, didn't argue the second element of the exceptionality element of Lopez de Sousa Fernandez. There is no discussion of paragraph 163. There's no discussion of the operational authorities and the operational obligation. Doesn't appear to have been advanced on that basis, although it's because the focus is on exhaustion of domestic remedies, it's not always easy to tell, but it doesn't appear to have been advanced on that basis at all. There's no discussion of of factors such as detention, care of the state, and so on, and how they.
Well, it's because of the view they take of the merits that they think that a domestic civil claim based on medical negligence was the appropriate remedy, and that's how you get to failure to exhaust domestic remedies.
It is, but it perhaps because the case essentially proceeded upon. The case is shaped by two matters. Firstly, the government's argument about exhaustion of domestic remedies, which means you don't get into a detailed analysis of the Article 2 case law.
Well, you say that, but I'm not sure that that's altogether right. But anyway, we can read it for ourselves.
My lords, my lady, you have the submissions. It simply doesn't deal with the operational obligation, and it doesn't appear to have been advanced on that basis. It's advanced, the complaint is advanced as a medical negligence complaint, and in those circumstances, the response of the government accepted by the court is, well, that can be pursued as a medical negligence complaint through a domestic remedy.
Well, don't want to take up too much time on this, but I thought that this was advanced pretty clearly as a complaint that the institution didn't refer the applicant's son to the relevant medical organisations to provide medical assistance. I'm looking at paragraph 48, page 2628.
Yeah.
And if there were a more demanding form of substantive obligation under Article 2, as Lord Reid observed, the usual position would be that leaving things to civil proceedings would not be adequate. When one thinks of deaths perpetrated by state agents, the jurisprudence is very clear that it's not sufficient to say, well, you could sue the police. There has to be an independent investigation instituted by the state. So in terms of what this case is deciding, isn't it a critical move for the court to say, we're going to treat this as only giving rise to the sort of investigative obligation that is associated with medical negligence cases, i.e. that people can bring civil proceedings, and that's good enough, and she hadn't, and that's why she'd failed to exhaust remedies. Whereas if they'd said that the substantive obligation was more demanding, they couldn't have said any of that, because clearly she didn't have to exhaust domestic remedies in order to say the state had to investigate these things.
The difficulty, in my respectful submission, with the Dumpy decision and placing too much weight upon it is, if there's any authority that's an outlier, it's this one, because it simply doesn't address the primary principles and the primary case law of the court. So if it had in mind the operational obligation and was purporting to say something about the operational obligation, one would expect to see that somewhere articulated in the judgment. One does not. If it thought this was a case that felt to be viewed as a deprivation of liberty case, and it's not one in which there wasn't a formal deprivation of liberty, but if it viewed the case through the lens of deprivation of liberty and the many authorities in relation to deprivation of liberty, we'd see that analysed in the judgment, and we do not. And we do not see any discussion of paragraph 163 of Lopez de Sousa Fernandez. And that's why I say it's a case which cannot bear the weight placed upon it by the Court of Appeal when set against all the other authorities that we've looked at. And as I say, I invite the Court's attention to what's said not only in our written case, but by the interveners in relation to Dumpy.
Oh, I'm so sorry. I'm just looking at the cross-references in paragraph 58 to paragraphs 190 to 192 in Lopez de Sousa. I mean, that does talk about one of the exceptional circumstances concerns a specific, sorry, it's paragraph 191, page 2780, concerns a specific situation where an individual patient's life is knowingly put in danger by denial of access to life-saving emergency treatment. I mean, that sounds like an aspect of the operational duty, which is being referred to. And appropriately so, one would think, given the nature of the complaint in Dumpy.
Yes, so in relation to that part of the Lopez de Sousa Fernandez judgment, it articulates what it says is the scope for Article 2 obligations arising in the ordinary hospital context, because that's what Lopez de Sousa Fernandez was concerned with. And it identifies essentially two ways in which that can arise. There's the broader systemic regulatory breaches, and then there is a narrowing, a very narrow, it can be termed, if you want to term it, an operational obligation, but it's not an operational obligation as articulated in the Osman case law onwards. It's a very narrow focus of knowingly putting someone's life in danger by denying access to life-saving medical treatment. It has nothing to say here about the more general, use the word general, broader operational obligation and the Osman line of case law. And Dumpy certainly has nothing to say about that.
Well, I interpreted paragraph 191 of Lopez as being operational and 192 as being systemic.
Yeah.
Yes, but described as being exceptional,
Yeah.
which isn't obviously the approach of the Osman
And
authority.
the operational in 191 depends upon actual knowledge, and at 194 it emphasises that the person has to be fully aware that the person's life is at risk. So it's not knew or ought to have known.
No,
It's
it's a
actual
much
knowledge.
narrower scope there.
It's a much narrower scope because it's owed to everybody, not just to people in detention.
Or the others who
Or
may
the
have-
others.
Yes, precisely,
Yes,
relating.
yes.
And the exception in 163, I understand is your case, that the exception in 163 brings you back to the general test of knew or ought to have known of an imminent risk.
Precisely. And then I should also just say in relation to Junpei, there's no discussion of Article 5, there's no discussion of deprivation of liberty, and there's no discussion of the protective obligation that may be owed towards those who are deprived of their liberty. It's just not viewed as that kind of case. So I'm conscious how much time I've already taken up. Can I move now to the other point I said I was going to deal with, which is just the question of remedy, and obviously I can come back to deal with any further questions of the court at the end, but I'm conscious of the need for the court to hear from Mr Maguire and Mr Beer.
Yeah, you're going to have to be very short because you've effectively used up your reply time.
I appreciate that, my Lord, and I accept that. So just in relation then to the issue of remedy, the remedies sought by the appellant are twofold. The first is essentially clarification of the law. They believe the coroner, in his ruling, got the law wrong, and are troubled by the fact that Ms Maguire's case has now become a basis for a narrow view or narrowing of Article 2. That obviously can be addressed by way of a judgment of this court if our arguments are upheld and appropriate declaratory relief. The second element to the relief that's always been sought in the case is a further inquest so that the Section 5.2 obligation, 5.1 and 5.2 obligation, and Section 10 obligation in the Coroners and Justice Act 2009 is met. And without taking the court to any authorities or documents, I'll just give my lords and my lady the references if I may. First point, in Armine, page 1987, Judgment of Lord Bingham, paragraph 31, the House of Lords emphasised that the procedural duty is not a minor or unimportant one, and then sets out the purpose of the procedural investigation. Point 2, the House of Lords in Middleton, judgment starts on page 2131, but the relevant part is page 2141, paragraph 4 onwards in the judgment, stresses the importance not just of the conduct of the investigation but its culmination. And then at paragraphs 18 and 20 on pages 2146 to 2147, the House of Lords confirms that a verdict which doesn't express the conclusions on a major issue canvassed in evidence cannot meet the expectations of the family of the deceased. And paragraph 20, an inquest ought ordinarily culminate in an expression, however brief, of the jury's conclusions on the disputed factual issues at the heart of the case. So that's the importance of the culmination of the investigation. That then found statutory force in section 5.1 and 2 of the Coroners and Justice Act. If the coroner had not, as we say, misdirected himself in his reliance upon Parkinson as to Article 2, the jury would have been required to make a determination as to the circumstances in which Ms Maguire came by her death. And you'll see that articulated in the case of Ginn, G-I-N-N, and the Inner London Coroner, a case from 2022, decision of the High Court, at page 3694, paragraph 104. And that determination could have included judgmental conclusions and could have included the consideration of possibly causative and not just probably causative factors. That's what didn't happen. And as the High Court ruled in Ginn, paragraph 143, page 3701, that thus warranted there being a fresh inquest. And so that is what we seek in addition to appropriate declaratory relief. First and foremost, that is the right course, we say, for Ms Maguire's family. They are entitled to have what the law requires, namely a determination of an inquest which looks at the circumstances of Ms Maguire's death and may set out, these are the findings of the jury, conclusions of a judgmental nature. But we say that is also something that is in the broader public interest, and I gave the court yesterday the references to the Leader and Sippold reports, which make clear that the deaths of people with learning disabilities, the premature deaths of people with learning disabilities, not infrequently because of problems in accessing healthcare, is a matter of some public interest and public importance. So for those reasons, my lords, my lady, that's the nature of the relief that we seek. Thank you.
Thank you very much, Ms Richards. Ms Maguire.
Yes. Yes, I've made a written submission, my lords.
Yes.
Section 4 of the document.
Yes, thank you.
And, my lords, the submission more or less says everything I wish it to say.
Ah, right.
I do not really have a lot to add to it. I just hope your lordships have time to read it.
Yes.
In response to paragraph 102 of the Court of Appeal judgment, I think your lordships are perhaps familiar with paragraph 102 already, so I don't need to read it out.
Yeah.
And I wish the court to suggest that as to whether by the evening of the 21st of February 2017, the state was or ought to be aware of the real risk of Jack Maguire's life. And the submission argues that all the evidence the state was or should have been aware of that risk, which indeed the Court of Appeal may have accepted by reference to the evidence of Dr. Good. However, in making the submission, it's not suggested that whether it's arguable as a real immediate risk to Jackie Maguire's life, and whether it's arguable the state was or ought to be aware of that risk, is something the court has to decide in this case as to whether an operational duty was owed to her. Because, of course, I have regard to the submissions made on behalf of Jackie's mother, the appellant. And those two things, real immediate risk to life, and whether the state was or ought to be aware of that, is a reference to the operational duty on the authorities. It's not part of the test of whether the operational duty has been breached. That's been confirmed recently in Morahan in the Divisional Court, and again in the Court of Appeal in that case. So it's to do with the operational duty. And then the submission proceeds by looking at 4 of the interested parties involved. And the first one is the National Health Service 111 service for the North West of England, operated by the North West Ambulance Service. And it focuses on a telephone call made at 3:36 p.m. on the 21st of February by a member of staff to the 111 service. And then it sets out the symptoms she reported, or which were elicited from her in paragraph 11 of the submission. The 3 key symptoms were vomiting of coffee grounds, severe stomach pain, and she had a fit, which possibly could be loss of consciousness. And Dr. Miller considered those symptoms. He's the gastroenterologist instructed by the coroner. Now moving on to paragraph 12 of the submission. And he had not seen that transcript before, but parts of it were read out to him when he gave evidence. And on hearing this new information, he thought these symptoms may have been symptoms of a perforation. And the submission is that any doctor on hearing these symptoms would advise that Jackie needs to go to hospital right away. That was the opinion of Dr. Napier in paragraph 13. And her opinion was that any doctor, for example, Dr. Adam, Jackie's GP at the Clifford Medical Practice, if he'd known of those symptoms, a hospital admission would almost certainly have been arranged. And if a patient like this is a first fit, she considered it advisable to have hospital investigation of it and would expect the advice to call an ambulance if this history is given. And this was consistent with her own oral evidence to the court. And notably in paragraph 14, the North West Ambulance Service Pathfinder tool at 82971 advises that a patient be taken to the emergency department if they're vomiting blood, have a shock or reduced level of consciousness, or have severe pain. So even though all those symptoms were reported during this telephone call, to the 111 service, it did not result in the sending of an ambulance. The Northwest Ambulance Service provided 2 witness statements from a Dr. Noble, and these are discussed in paragraphs 15 right through to paragraph 19. And she doesn't say that an ambulance should have been sent, to summarise it. She carries out an audit, and mistakes were made, but she doesn't concede that an ambulance should have been sent in response to those symptoms. And my submission is it certainly should have been. But she wasn't wearing her doctor hat. She was a doctor with 20 years medical practicing experience. And if she'd been wearing her doctor hat, surely she knows that the vomiting of coffee grounds or reduced level of consciousness or having a fit or severe stomach pains requires the patient to be taken to the hospital and quickly. And she must know that. But she simply carried out an audit by looking at the transcript of the telephone call. She also seeks to explain why an ambulance was not sent. And that's, I refer to that in the submission as well. But the substance of this part of the submission is that, referring to paragraph 26, that it is arguable that by 336 there was a real immediate risk to Jackie's life. And more detail is given of that in paragraphs 91 to 93 of the submission. And it's arguable the 111 service operated by NWAS should have been aware of that risk. Just acting in accordance with their own Pathfinder tool, they should have been aware of that risk. And in relation to arguable breach, the simple step the service should have taken was to effect attendance of an ambulance upon Jackie Maguire. In relation to taking of steps, arguable is defined at paragraph 75 of the Court of Appeal's judgment herein as being when a credible suggestion is made that the state has breached its substantial Article 2 obligations. And the submission is if an ambulance had been arranged, it is arguable there may well have been a better outcome for Jackie. She may well have been taken to hospital about 4 p.m., 4:30, and not later on that day. So that, in outline, is the submission as it relates to the 111 service. The more detail is in the submission itself.
Yes. In
relation to Dr. Adam, beginning at paragraph 27, in response to several telephone calls from the care home that afternoon, he telephoned the care home at 4:59. And he spoke to a member of staff, Miss Lasaint, and the evidence she gave is at paragraph 28. And the evidence Dr. Adam gave is at paragraph 29. It was not audio recorded, so reliance is placed on notes. Ultimately, and this is a reference again to paragraph 29 near the bottom, he conceded that based on the information he was given by Miss Lasaint during that telephone call, he should have gone to see Jackie. So in relation to real and immediate risk, where real shouldn't involve hindsight, that concession is important because he bases it on the information he was given during the telephone call and not on anything he learned thereafter. It's based on the information he was given by Miss Lasaint in paragraph 28 of the submission. She reported to him that Jackie was vomiting. She'd had a fit at 2:15 p.m.
Yes.
And she thought it was a done deal that he was coming to see her, but the details in paragraph 28, my lords. And then in paragraph 30, in relation to what Dr. Adam knew before he telephoned the Clifford Medical Practice at 4:59, there are out-of-hours entries made in relation to Susan Aiken's telephone call at 3:36 p.m. But in outline, it seems that he hadn't seen them. And he wasn't aware, for example, of hematemesis that was reported. and wasn't aware, it seems, of the vomiting of coffee grounds that Susan Egan reported during the call at 3:36 p.m. as well. But there was a report electronically transmitted to the Clifton Medical Practice at about 3:46 p.m., which is 73 minutes before Dr. Adam telephoned the care home at 4:59. So obviously there's an issue as to why he wasn't aware of the information contained in the out-of-hours report, and possibly he should have been. Paragraph 31, Dr. Napier, who's a GP expert instructed by the coroner, says the information about vomiting coffee grounds, messes in these out-of-hours reports, which originate from this telephone call, appears not to have been given to the GP. In paragraph 32, she's critical of Dr. Adam, and your Lordship can see what that criticism is. While I can see his reasoning and find no fault with what he appears to be ignoring the fact that she'd had a fit and a long history of diarrhoea and now vomiting, I feel he needed to find out if she was dehydrated and why she'd had her first fit. The Down syndrome and communication difficulties would make her difficult to assess, and she's being looked after by carers, not by nurses in a nursing home. If a patient like this has a first fit, I consider it advisable to have a hospital investigation of it. I would expect the advice to be to call an ambulance if the history is given. And then in paragraph 34, her opinion was that Dr. Adam should have gone to see Jackie. And as seen in paragraph 13 of the submissions, he said Jackie should have gone to hospital in the afternoon of the 21st of February. So that's important because this is the afternoon period, whereas the coroner and the inquest seems to have focused on the evening period. And it's almost like the afternoon period has been overlooked. So in paragraph 35, to conclude in relation to Dr. Adam, my submission is clearly arguable that on the evidence, there was a real immediate risk to Jackie's life by the time of this call to the care home at 4:59. And reference has already been made to paragraphs 91 to 93 below in this regard. Perhaps, my Lord, I could perhaps have a look at 91 to 93 of the submission. And the submission in paragraph 91 is that as to when the real immediate risk to life first existed, arguably this was no later than 2:15 p.m, when Jackie had breathing difficulties early that morning and had been ill as known for many days, had the first fit, and refers to evidence of Dr. Good, a pathologist, that she may possibly have been septic at this time, whether from pneumonia or pneumonia and peritonitis combined. Dr. Good does not give evidence as to what the range of mortality was at this earlier time of the day, but if it was as high as 40% by the early evening, then the risk at this time of the day was arguably significant. In paragraph 92, whether or not Jackie was septic in the afternoon period, she was clearly extremely ill, as evidenced by these symptoms reported by Susan Egan during this call at 3:36, regarded as evidence of a perforation by Dr. Miller, as requiring an ambulance and hospital admission by Dr. Napier, and which symptoms met the NWAS Pathfinder 2 criteria for a life-threatening emergency. And therefore the submission is that the risk to Jackie's life was significant from no later than mid-afternoon on the 21st of February, and the evidence in the case establishes from that point onwards her condition worsened all the way to a point of death. So it was a continuing risk. And then, my Lords, therefore going back to paragraph 35, again it looks at the evidence that's just been summarised from Dr. Adam and Ms. Saint in the paragraphs above. And again points out that Dr. Adam ultimately conceded that he should have gone to see Jackie, and something he was criticised by Dr. Napier for not doing. And near the bottom of paragraph 35 in brackets, if he had gone to see Jackie, it is submitted he would likely have seen Jackie's coffee ground vomit on her blanket. And then there's two references, and that's in fact to the evidence of Miss Saint, with whom he had the conversation on the telephone at 4:59. And Jackie was clinging onto her blanket in her settee in her front room, and she wouldn't let go of it. And so it was there during the course of the day and the early evening until she went to bed. So had he attended on her, likely he would have seen that coffee ground vomit on her blanket, as it was seen by Miss Saint herself. There also had been some changes. The Clifton Medical Practice again in paragraph 35 near the bottom, now had a policy of annual health checks for people such as Jackie. This is the evidence of Suzanne Chaplin. When somebody from the care home now contacted the Clifton Medical Practice, residents with a lack of capacity or learning disability now automatically received a home visit. There's also a concern, my lords, that Dr. Adam did not know of the out-of-hours report and of the NHS 1 report timed at 3:46, and has seen Dr. Neighbour queries why this information was not given to him. And an issue therefore arises as to why he was not told, or as to whether he should have found this information out for himself. And it is admitted this is an important matter, as the Clifton Medical Practice clearly had in its possession information about Jackie's life-threatening symptoms, originating in a telephone call for Susan Egan at 3:36 p.m. But for some reason, Dr. Adam was not aware of them, or was not aware of the report. In paragraph 36, in relation to arguable breach, the simple step Dr. Adam should have taken was to visit Jackie. If he had done so, it is arguable there may have been a better outcome for her. And then, my lords, in relation to the third interested party focused on, paragraph 37, this is the North West Ambulance Service, the second interested party. Paragraph 37, it's not disputed that a paramedic with 5 months' experience, accompanied by an emergency medical technician, attended the care home just after 8 p.m. on the 21st of February, so now we're looking at the evening period. And this resulted from a telephone call from the care home at 7:14 p.m. by Miss Lasaint. What is disputed is what they were told by the care home staff about what had been happening to Jackie and whether she'd have left Jackie to care home overnight. And then there's a summary of Chloe Lasaint's evidence in paragraph 38. Going to bed early was unusual for Jackie. She collapsed at the bottom of the stairs. She'd seen Jackie's coffee ground vomit for herself. She told Hannah Ayres, the paramedic who attended at this time, that Jackie was vomiting light brown coffee. And she told the ambulance crew what had happened that day and everything she had been told. In several places in her evidence, she said the crew would not manhandle Jackie to get her out of the house. She said she told the ambulance crew Jackie's mother said that Jackie could be sedated to get Jackie to hospital, but the ambulance crew would not sedate her. Her evidence was, I think, confirmed in relation to sedation by support worker Cheryl Clayton. She also confirmed that Jackie collapsed at the bottom of the stairs. She was the one who spoke to Jackie's mother on the telephone. And Jackie's mother said Jackie was incapable of making a decision not to go to hospital, and she would like the paramedics to sedate Jackie to take her to hospital. She passed on this information to Miss Lasaint, who passed it on to Hannah Ayres, who said they were not allowed to sedate. The evidence of Hannah Ayres, again, this is a short summary of the evidence, only partly audio recorded. So reliance is again made on solicitor's notes. She said she was told Jackie had a fit at the bottom of the stairs. She thought this happened at 3 p.m. rather than, my lords, when it did happen at 7. She deemed Jackie not to have capacity. She's cross-examined at some length by counsel on behalf of Blackpool Victoria Hospital. And, my lords, that's at A2 1332A 1334A. She was not told the vomit was coffee grounds, did not elicit that information. She says she would have asked about it. She said the force needed to remove Jackie from the property. The risk of her falling out of the carriage chair would have been catastrophic. And she also said, my lord, even if she'd known of the second fit, i.e. at 7 p.m, she did not consider it appropriate to manhandle Jackie. She said sedation was not discussed in any way, shape or form. And referring to Jackie, she said there wasn't anything dramatically jumping out with regards to her observations. And for me, there wasn't anything that was basically saying there was a real immediate risk to her life and it wasn't a medical emergency. With regard to Jackie's apparent refusal to leave, she said she really wanted Jackie to go to hospital, but found herself in a no-win situation, as she did not want to use force and legally I had no other alternatives. In paragraph 40, her colleague Graham Peters gave evidence. He actually thought the fit had taken place recent to the ambulance attending, i.e. at 7 p.m, and not, as the paramedic Miss Ayres suggested, at 3 p.m. So his state of mind was different to hers. In relation to paragraph 41, the paramedic said she was not given the information Chloe Lasaint provided to the NHS 111 service during the call, and she would have expected that information to be passed on to her. My lord, some of that information is to be seen in the out-of-hours report relating to this call at A2 106. And that out-of-hours report includes collapse 3 times, struggling to breathe, crushing pain, chest, upper abdomen in the last 24 hours, and vomiting coffee grounds. And then in paragraph 42, why this information was not passed on is explained in the witness statement of Mr. McCormick Gray, provided to the coroner by NWAS. That's at 82972. And paragraph 9 of which, in paraphrase, state the primary method used to dispatch information from 111 to 999, an emergency dispatch system via electronic transfer failed in Jackie's case, so the backup manual system was used. The backup system was the making of a telephone call from 111 to 999, which then notes the information received during the call. In Jackie's case, the only information passed by 111 to 999 during the backup call was that Jackie had Down syndrome and learning difficulties and poor vision, and the diagnosis was having faints. Only information relating to faints was noted by 999 and transmitted to the ambulance crew, as confirmed by the paramedic Miss Harris herself when she gave evidence at 821331CD. And my lords, this very limited information noted by 999 and passed on to the ambulance crew is what the divisional court herein referred to as administrative error in paragraph 19 of its judgment. It did make a comment on the failure of the electronic system of transferring information from 111 to 999. It didn't pass comment on that. It's possible it may not have been aware of it. And then in paragraph 43 of the submission, Mr. McCormack Gray says, but for the failure of the electronic transfer system, the NWAS dispatchers would have had access to the full range of questions and answers given by Miss Lasaint, and then selected relevant information and transmitted the details at any point in response to Jackie. In paragraph 14 of the statement, he adds that changes have been made so that now the electronic transfer system fails, 111 staff can manually input all details directly into the 999 system rather than having to make a telephone call. And then he gave evidence of my submission consistent with his statement. And referring to 821502C of the transcript of his evidence, the words, well, I'll read out what it says. He said, as to any information of age, sex, history, injuries, or to condition relating to patients should be recorded onto the notepad or the report so that they can be sent to the crew, also to factor into deployment decisions. Those latter words, also to factor into deployment decisions, aren't in the transcript said to be inaudible, but on listening to the actual recording, it's actually clear. You can hear him say very clearly, also to factor into the deployment decisions. The appellant agrees that's what he said. The respondent hasn't actually replied to me on that point. He also suggested the failure of the electronic transfer system in Jackie's case may have been something to do with a problem the technology had with the address. And then Dr. Napier again, paragraph 44 of the submission, notes that some observations were done on Jackie by the paramedic, and she notes what they were. And then, my lord, she bases her opinion based on those observations taken by Miss Ayres, and not on anything Miss Ayres did not know or found out subsequently in relation to real and immediate risk and not using hindsight. So considering the same observations taken by Hannah Ayres herself, she said the observations found abnormalities which in my view were significant and warranted immediate hospital admission. So my submission, my lord, she takes a more serious view of the observations than Hannah Ayres herself, which are referred to in paragraph 39, which is that there's nothing dramatically jumping out with regard to her observations. When those same observations are considered by Dr. Miller, Dr. Napier, she has a different view. Likewise, Dr. Good, the A&E expert instructed by the coroner, paragraph 45 of the submission, he also considered those same observations and nothing that Miss Ayres did not know, or claimed she didn't know, such as vomiting coffee grounds or stomach pain. And he also took a more serious view of those observations. And in paragraph 911 of his report, he said the evidence for likely infection with a moderate to high risk of sepsis, which had progressed to septic shock by the time Jackie arrived at hospital the following morning. In relation to Dr. Napier, going back to paragraph 44, the more serious view she took was she thought that Jackie was really showing, in my view, great signs of sepsis, and the situation was a medical emergency. We're seeing in paragraph 39 of the submission that Miss Ayres, now analysing those same observations that she herself took, thought that it was not a medical emergency. And then in paragraph 46, there's a report of Vincent Romano, an advanced paramedic employed by the North Ambulance Service. He didn't comment on why Jackie's observations were only taken once, even though the ambulance crew were there for over an hour. And he didn't comment on why the paramedic did not contact ambulance control at any time, likewise when he gave evidence. And of course, he's not an independent witness, but nevertheless, several abstract comments he made in his evidence are relevant. He said a seizure several hours before shouldn't be ignored. An option is to physically manhandle the patient to a carriage chair. He said, if there's 2 members in the crew, they can request backup, and that may give them more scope to move a patient. And my lords, that was actually envisaged by the paramedic who took Jackie to hospital the following morning, Miss Banks, who said in her evidence that she and her colleague would not have been able to pick Jackie up off the bathroom floor by themselves, but the staff said it would help, rather than them having to call out another crew. And my submission, my lords, this wasn't available the night before because there were only 2 staff members on duty. And the other residents were up and about at that time, fully occupying one of those staff members, Miss Clayton. And in paragraph 47, Mr. Romano said that as an advanced paramedic, when he was operational, he responded to the more serious patients. And of course, my submission is that Jackie certainly was a more serious patient. But ambulance control were not aware of that because of the failure of the electronic system for transferring information from 111 to 999. So to conclude, in relation to the Northwood Ambulance Service, my submission is it was arguable in the evidence there was a real immediate risk to Jackie's life by the time the ambulance attended the care home just after 8 p.m. on the 21st of February. This is evidenced by the said symptoms reported by Chloe Saint and referred to at A2106, struggling to breathe, crushing pain, chest, upper abdomen in the last 24 hours, vomiting coffee grounds. And also, have regard to the evidence of Dr. Good, which is referred to in paragraph 89 of the submission, evidence which has become quite well known by now, that by about 8 p.m., 7 p.m. in the evening, Jackie had a mortality risk of 30 to 40%. And the Court of Appeal actually referred to that in paragraph 102 of its judgment. And it's arguable, therefore, that the Northwood Ambulance Service should have been aware of this risk to her life. Now, there's a conflict, of course, between the evidence of Chloe Saint and Hannah Ayres. Miss Ayres doesn't accept that Mr. Saint told her about the second fit. As she says, Mr. Saint says she did tell Miss Ayres of the coffee grounds. Miss Ayres says she didn't. But Miss Saint did tell Dr. Adam of the coffee grounds, in which case the jury may have wondered why she said she told Ayres of the coffee grounds if she did not. There's also a conflict of evidence about sedation, with Miss Saint saying she discussed this with Miss Ayres. Miss Ayres vehemently denies this, saying it wasn't discussed in any way, shape or form. But Miss Saint's evidence is corroborated by the evidence of Cheryl Clayton, as just seen. She also claimed to have seen that Jackie was a catastrophic risk if force was used to remove her, which the jury may have contrasted with the evidence of Charlotte Banks, who gives them a detailed account as to how difficult it was to get Jackie out to the ambulance the following morning, but which was done without injury to Jackie or anybody else. So in my submission, on the evidence, the jury could quite properly have concluded that Mr. Saint did, for example, tell Miss Ayres of the coffee grounds, which is a life-threatening symptom, my lords, in which case it is clearly arguable that Miss Ayres should have been aware of the real immediate risk to Jackie's life that arguably existed by this time. Again, that's a reference to Dr. Good's evidence of a mortality risk of 30 to 40%. And paragraph 50, my lords, it's arguable, because there may be a credibility doubt about Miss Ayres, that she placed down the significance of the observations she took from Jackie in relation to her remark that there was nothing jumping out about Jackie's observations, or alternatively failed to appreciate their significance when she says there was not a real immediate risk to life and it was not a medical emergency. If the latter, those same observations, as already seen, my lords, were analysed by Dr. Napier and Dr. Gould. Dr. Napier thought they meant Jackie needed immediate hospital admission, and they indicated great signs of sepsis, and it was indeed a medical emergency, contrary to the view of Miss Ayres. And Dr. Good thought they indicated likely infection, with a mortality risk of 30 to 40% at this time. It is also arguable, my lords, that Miss Ayres did not attach enough weight to the significance of Jackie's fits, even saying, as seen, my lords, that even if she had known of the second fit just prior to the ambulance attending, she still did not consider it, even then, appropriate to manhandle Jackie. And then in relation to arguable breach, 3 examples. Jackie, the North West Ambulance Service should have got Jackie face-to-face with a doctor, whether at the care home or at the hospital. The 3 examples, firstly, we haven't seen this yet, but in paragraph 59 below, we see that Hannah Ayres gives evidence that she herself should have passed on that information about the observations to Dr. Fairhead during the out-of-hours conversations that she had with Dr. Fairhead at 8:30, and she says she did not know why she didn't. And that's in paragraph 9, just on the other page of the submission, my Lords, paragraph 59. And then going back to paragraph 51, it's submitted that had she passed on Jackie's observations to Dr. Fairhead, having regard to Dr. Fairhead's own evidence to be referred to shortly, Dr. Fairhead would have advised immediate hospital admission, or if Jackie refused to go, she would have sent a visiting doctor. Secondly, if Hannah Ayres, and this is a second example of arguable breach, if Hannah Ayres thought she was in a no-win situation, this is one of her own making for not passing on proper information to Dr. Fairhead, but also because she at no time contacted Ambulance and Control for assistance. And Dr. Napier opined in a report that the fact that Miss Maguire had no capacity and was subject to a DOLS complicated matters, but I feel that this could have been sorted out in her best interest. And it is submitted if Hannah Ayres had taken this simple step of contacting Ambulance Control, then this would indeed have been sorted. And, for example, another ambulance at least would have been sent to help to lend physical assistance. But one way or another, arguably Jackie would have been taken to hospital and her best interests would have been met. Then,
now, Mr. Maguire, I'm sorry to interrupt you, but you had been allocated 5 minutes.
all right.
And obviously, what you're telling us is relevant and valuable, and in fact, your submissions are the only submissions we have which go into the facts in detail, and that's very useful to us, and we're grateful for that. But you are, I'm afraid, eating into the time that Mr. Beer requires. You can be sure you've taken us about halfway through your submissions. You can be sure that we will read them carefully as a whole.
Well, yes, my Lords. Well, unless your Lordships have any questions about the submission now or later, then which I can answer.
We were just saying that there are very helpful evidential references in your submission, and Lady Rose and I, and maybe others, have been trying to find those in the bundle. It may be you're not the best person to assist us with the electronic bundle references, but it would be useful if at some point we could be provided with a copy of your statement with the cross-references to the documents we have. My slight fear is that you're referring to something that isn't before us, but we obviously need to have access to it.
Yes, it's actually the page numbering, my Lords, in the top right of the... when you go into the core bundles, for example, core bundles 1 and 2, there's a page number in the top right of every page.
And are you able now to help us with an electronic page number?
No, my Lords, that's the page at the bottom of the page.
To try and help, I think they are the page references to the appendices.
Yeah.
Right.
Appendices 1 and 2. So A1 means Appendix 1, A2 means Appendix 2. Obviously, that's been superseded by the master PDF electronic bundle from which we're all working. So it would be a relatively simple task to translate those appendix references into electronic bundle PDF references.
But if it can assist, my Lords, my Lady, Ms. Cohen, my junior, has done that exercise by handwriting on our copy of Mr. Maguire's submission, so we can easily put that into a format that gives the equivalent electronic bundle reference for every single reference that Mr. Maguire.
Is there a simple key, like you add a certain number? No,
I don't think
not.
it was. It took some time, but Ms. Cohen, having done that exercise, we're happy to pass the rewards of that and her time on to the court.
That's very helpful. Well, we're very grateful to your junior and you, Ms. Richards.
Yeah. Well, unless your Lordships have any questions.
I don't think so. You're very largely giving us, you're pinpointing for us relevant passages in the evidence, and that's very helpful. Thank you.
Thank you, Lords.
And allow me, before you sit down, can I allow me on behalf of the court to express our sympathy with you and your family in your loss.
Yeah, thank you, Morris.
Mr. Beer.
Lord Lady, consistently with the approach that he took in the divisional court at the permission stage, at the substantive stage, and then again before the Court of Appeal, the coroner appears before this court in a position of neutrality as to the outcome of the appeal. The position is slightly different in this court to that in the divisional court and the Court of Appeal, of course, where United Response, the owners and operators of 85 St Anne's Road East in Lytham St Anne's, took an active role. The court will have seen, perhaps, the reference in the divisional court's judgment at paragraph 29. No need to go there, it's key documents, page 183. Quote, the principal opposition to the claim, both orally and in writing, was provided by United Response, who supported the coroner's decision both in relation to Article 2 and neglect. United Response has decided, like all of the other interested persons, save for Mr. Maguire, not to appear on this appeal. We, of course, realise on this side of the court that that means the court will not decide the important issues raised on the appeal in the context of adversarial submissions. That's unfortunate. And in particular will not hear submissions that oppose or which test those of Ms. Richards. As we've explained, however, in our written case, our approach reflects a long line of authorities concerning the proper approach that a coroner should take to a claim for judicial review of their decision, culminating most recently in a case called Garani, in which Lady Justice McCurr and Mr. Justice Garnham noted, this is 3705, no need to turn it up, the coroner is a judicial office holder. A normal course for a judge or other judicial office holder facing a judicial review is to adopt a neutral stance in the proceedings and to appear, if at all, not as a party to defend her decisions, but simply to offer the court her assistance. So that's the approach we took, you will have seen, in the written case. Yeah. And it's the approach that I propose to take today. It's reflected in the time estimate that I gave of an hour and a half, which wasn't reflective of any pre-planned submissions when it was given, just a reasonable period of time to address any issues that might need to be picked up and raised by the appellant. It's common ground that the investigation which the coroner undertook was diligent and thorough. And were Article 2 to have required it, that investigation discharged that part of the enhanced investigative obligation, the investigation bit. Thus, the coroner conducted a 9-day inquest, sitting with a jury, and set the scope of the inquest very broadly, looking at all events from November 2016 onwards. I should say, however, that the scope of the inquest did not include as issues amongst the following, and you'll see these, this is a reflection of parts of Miss Richards' written case. It didn't include the training of general practitioners in the Mental Capacity Act 2005. It didn't include the training of ambulance personnel in the Mental Capacity Act 2005. It didn't include the existence or otherwise of regulatory enforcement mechanisms and the statutory enforcement role of the Care Quality Commission, the legislative framework under which the Care Quality Commission operates, the guidance that it issues, and the quality of its performance in this case. It didn't include the scope of the inquest, the general operation of systems for communicating information between NHS 111, the ambulance service, and out-of-hours GPs. It, of course, looked at what went wrong in the non-transmission of a piece of information in one instance in this case. It didn't include within its scope whether there was, quote, a corporate understanding within the health and social care provider sector generally on the implications of the Mental Capacity Act. All the things that I have just mentioned come from paragraphs of the printed case 55 and 57 of the appellant, where it said these are the systemic issues that were required to be left to the jury because there was an arguable case for their breach. Now, the court will appreciate, I hope, that in coronial proceedings, where there are no pleadings, there are no statements of case, there is no indictment, it's necessary to identify, as part of an iterative process, the issues on which evidence is necessary. That's often done at pre-inquest review hearings. You've seen in this case the coroner conducted 2 of them in September and December 2017, where decisions can be made following submissions to expand or constrict the scope of the inquest. And so, to take but one example of the list of things that I've just mentioned that weren't within scope, the training of general practitioners in the Mental Capacity Act, what can't happen is that a few questions are asked of a GP about her training and on the understanding of the Mental Health Act, and then that is translated into a generalised allegation that there is a systemic problem, a systemic fault, a systemic failure. In order properly to explore that issue, the training of general practitioners in the Mental Capacity Act, one would need to identify that issue at a pre-inquest review, would need to bring it in scope, a decision be made on that, would then need to seek evidence relating to it, perhaps from the GMC, perhaps from the relevant Royal College, perhaps from those responsible for the initial and refresher training of GPs to see what was said about training on the Mental Capacity Act. And one would also have to try and track its relevance to this death, if any. After all, if there is a proper systemic issue to be left to a jury, then this will be translated into a question asked of the jury as part of a questionnaire that elicits from them a narrative conclusion. A question about the adequacy of training of GPs on the Mental Capacity Act 2005. So that's the process that needs to be undertaken in order for systemic issues, any systemic issues, but systemic issues such as these, to be brought before the inquest and for an adequate explanation, culminating, if appropriate, in an issue being left to a jury or a coroner leaving the issue to him or herself.
I understand that there's been absolutely no challenge at all to the coroner's decision as to the scope of the inquest. And is there any aspect of the systemic case that is presently being made by the appellant that was within scope?
I think it's fair to say that it didn't work like that.
Yes.
What happened was at the end of the evidence being called, 2 issues were identified that were said to be systemic issues.
And sorry, what were they?
One was concerning record keeping.
Do we have in the bundle the questions that were identified?
What we do have is, if we look, please. If the court gives me a moment, I should have a reference.
well, don't take up your time now, which is slightly constrained.
Which is valuable, yeah.
But if perhaps a note could be sent through afterwards, if there is a document that we can usefully refer to.
Yes, no, there wasn't. What happened was the evidence was called. There was an adjournment to allow for the interested persons to file written submissions. You haven't got those before you say for one, which for NWAS, which seems to have found its way into the bundle, saying what are the issues that you say amount to an operational breach or a systemic breach. Why was the operational breach owed? Why was the operational duty owed? Why was the systemic issue owed? And then there was a day of submissions on that. You've got these submissions in the bundle. The reference to the oral submissions is 1017, where they start.
I do apologise, but was the scope of the inquest determined in writing? Is there a document we can turn up?
No, that was at the two pre-inquest reviews, and you've got the transcripts of the two pre-inquest reviews.
Right.
I can give you the references to those. The transcripts of the two pre-inquest reviews. The first was on the 8th of September 2017, and the reference is 656 and following. And the second pre-inquest review was on the 18th of December 2017, and the reference is electronic bundle 711 and following.
Thank you.
So, in the run-up to the hearing of the inquest itself, the coroner commissioned, in the sense that he instructed.
You said two issues were identified as systemic issues. One was record keeping.
Yes.
And what was the second?
Well, the second was the failure to take Miss Maguire to hospital on the evening of the 21st, which was said to disclose a systemic issue. As I was saying, in the run-up to the inquest itself, the coroner commissioned, in the sense he instructed and paid for, a series of reports from the independent experts. If I can just give you the references to those in a shorthand form. Mr. Good, Peter Good, a consultant in accident and emergency medicine, report is at 1416. His evidence is at 840. Dr. Janet Napier, an expert in general practice medicine, report is at 1405. And her evidence is at 903. And thirdly, Dr. John Paul Miller, a consultant gastroenterologist, whose report is at 1452 and whose evidence is at 994. The coroner sought extensive disclosure from all properly interested persons and cross-disclosed that material to the other properly interested persons, and obtained witness statements from a very wide range of individuals, calling 29 of them at the inquest. He made a prevention of future deaths report, a PFD report, under paragraph 7 of Schedule 5 to the 2009 Act. That's at 963 of the electronic bundle. I don't invite it to be turned up. Now, of course, as the court knows, the issue on the appeal is not, therefore, his conduct and his preparation of and for the inquest. The issue raised on the appeal concerns the determination that is said that ought to have been left to the jury, i.e. in the language of Section 5 of the 2009 Act, whether it was, quote, necessary in order to avoid a breach of convention rights for how Jackie came by her death to be read as meaning in what circumstances Miss Maguire came by her death. I should say at this point that in response to a question from Lord Stevens in relation to the issue of arguability, we take the law to be that in relation to the issue of whether there has been a breach of any positive duty that's owed, whether systemic or operational, then the relevant question for a coroner to ask themselves is whether there has been an arguable breach, or in the words of the Court of Appeal, a credible suggestion. But the position is different in relation to the legal issue of whether such duty, operational or systemic, is owed in the first place. Now, certainly at the point of commencement of the investigation, at the pre-inquest review stage, or indeed in the course of the inquest itself, before the determination stage has been reached, it seems reasonable to approach the question of the existence of a duty, again by reference to an arguability criteria. Otherwise, it's self-defeating, perhaps and illogical. The very purpose of a decision in the run-up to the end is in part to decide how broad the scope of the inquest should be and what evidence needs to be called. It is just looking at the narrow how question, or is it looking at the wider in what circumstances question, and therefore may regulate what evidence will be sought out, which witnesses will be proofed, and which experts might be instructed and the like. And so it would ask too much to establish the existence of the duty at that stage. But the position would appear to be different when all the work has been done, when the evidence has been called, and the coroner has to decide what conclusions to leave to himself or to a jury. At that point, it would appear that the arguability of the existence of the duty falls away, and instead it must be established that there was a relevant duty owed. That's a legal issue required to be decided by the coroner, because he or she must decide whether, for the purposes of Section 10 of the Act, read with Section 5.2 of the Act, it's necessary to determine in what circumstances the deceased came by their death in order to avoid a breach of a convention right. We should probably just remind ourselves of Section 5 and Section 2.
Can I just ask some questions just to try to clarify in my own mind what's going on?
Yes.
Obviously, in deciding on the scope of the inquest, I'll start again. The coroner himself may be, as it were, the arm of the state which is responsible for complying with the state's obligation to carry out an Article 2 compliant investigation.
That's what Middleton essentially says.
Yeah. I mean, this sort of problem obviously arises all the time in Northern Irish cases, which we deal with quite often. It also has practical importance, as I understand it, to the question of whether legal aid is available for the representation of the family at the inquest.
Yes, and the court will have seen what the Lord Chief Justice said about that in Morahan, that he rather deprecated the reverse engineering that was going on.
But the implication of that is that I assume that the coroner has to have formed a view by the commencement of the inquiry as to whether it is one being carried out in pursuance of an Article 2 procedural obligation.
Yes.
And on what basis does he form that view?
What generally happens is that deaths where there has been, where it's at least a possibility there is quite often a report or reports from a regulator or regulators. And they form the springboard for that decision. Some coroners say, we need to wait a little while. I think this is possibly an Article 2 case. I need to gather some more evidence. I've read the report of the regulator, but I want to find some evidence for myself before I make the Article 2 inquest decision. And quite often they come under pressure from the families for the funding reason that my Lord has mentioned. No, we need an early decision, please, on that. So there's often a tension.
Yes.
So they've got to start somewhere, is the answer to my Lord's question, and they work on the basis of, quite often, an investigation report.
Yes. So he's forming whether or not this is what Strasbourg would require. As a matter of practice, the coroner is basing his decision as to whether he is performing an Article 2 investigation on whether there appear to be, perhaps one could say, serious issues to be investigated, as to whether there may have been a breach of a substantive obligation.
Yes, some coroners take a precautionary approach and rely on those passages in Hurst and Smith which say it makes no difference to the nature of the investigation. I'm going to conduct my investigation as if Article 2 applied without making a determination on that.
I see.
So in the run-up to the inquest, we'll treat Article 2 as having applied without making a determination.
Yes.
I will do all of the things in terms of investigation that Article 2 would have required of me.
Yes, that's very helpful. Thank you.
Right, so if in this case the coroner had arrived at the conclusion that he ultimately arrived at, that this was not an Article 2 inquest, if he'd arrived at that, say, after the, or even before the September pre-hearing, are you suggesting that actually the scope of the inquest and the number of witnesses would probably have been the same, or would definitely have been the same as it was?
Well, I can say yes to that, because if you remember, slightly oddly, the way the issues transpired was he made a decision early on in relation to Article 2. And
right, well, perhaps not this inquest, but inquests more generally.
Yes, in many instances, I think I can say the scope of the inquest in terms of the issues addressed and the breadth of the evidence obtained, both lay and expert, doesn't turn on the nice point of Article 2.
And you mentioned, I think, Hurst and another case.
Smith.
Smith.
Yes. I can chase down the references to those. There is an extended debate within either of them, in both of them, as to whether or not it actually matters, whether Article 2 bites or not to the investigation stage, and they tend to come to the conclusion, no, it's really at the latter stage. So I was addressing, I think, my Lord Stephen's point, that arguability as to the existence of a duty will probably fall to be applied as the test or criteria at all of those points. But when one comes to the end of the process, the determination stage, one must go back to the Act. And I wonder whether we could look at the Act.
Is there any authority on that point?
No, not so far as I'm aware. The courts tend to use the compendious phrase arguable breach, referencing the whole of the process and don't compartmentalise it in the way that I have just done.
I was just wondering because, I mean, there was no dispute about that. Well, there was no dispute that Ms. Maguire was vulnerable and under the care of the state. I suppose there may have been some dispute about whether she was detained. And the only other factual issue, potentially any other factual issue, is whether there was a real and immediate risk to life. And depending upon how you formulate the operational duty, why do those factual decisions about whether she's vulnerable or whether there was a real, that is not a fanciful, but a real risk, an objective risk to life, why should those not be taken by the jury? Or put another way, what is the statutory provision that sets out what the jury decide and the circumstances in which they make those decisions?
There isn't one.
There isn't one.
But can I deal with the antecedent stage before it gets to the jury?
Yeah.
And can we turn up 1920, please? You should have Section 5 of the 2009 Act. And we'll see that this is under the cross-heading purpose of investigation.
I'm sorry, which section?
Section 5.
Oh, fine, thank you.
Sorry, the page reference again?
1920.
Yes, thanks.
You'll see that the cross-heading is purpose of investigation. You'll see that the way that Section 5.2 operates, this is all about investigation. The four matters which are the purpose of the investigation set out in 5.1a and b, who, how, when and where. But then the how in 5.1b is to be read as including the purpose of ascertaining in what circumstances the deceased came by his or her death by Section 5.2. And then if we go over the page, please.
And just on that, as I understand it, the word how had been authoritatively determined as to its meaning in
Jameson.
Previous cases.
Yes.
So that you didn't need a separate provision saying how it would be read in a non-Article 2 inquest, because that was already established.
That's correct, yes. The sort of the beginning and the end of that question of what how means is answered by Sir Thomas Bingham, the then Master of the Rolls judgment in the Jameson case. And so this was legislation made in the knowledge of that decision.
And then is Section 5.2, is that the consequence of Middleton?
It is, yes. That's a statutory reflection of the court's decision in Middleton. Then if we can go over the page, please.
So, and just on that, I think in Middleton it was said that you could construe the word how more broadly anyway if it's Article 2, but this is statutory confirmation, so one doesn't need to go through that intellectual exercise. Is that right?
Yes, there was a read down or read in, and then Parliament caught up.
Yeah. Okay.
Yes, then the court was dealing with the Coroner's Act 1984.
So the Jameson case you referred to is on the meaning of how, when you're not dealing with an Article 2 case.
Yes, and you'll see in the lexicon of coronial law, people refer as shorthand to a Jameson case or a Jameson inquest or a Middleton inquest.
Right.
So Section 10, please, which is the important focus for the moment. Here you'll see the cross-heading is outcome of investigation. And you'll see the way that it works. Excuse me. Section 10(1)(a), the senior coroner, or if there's a jury, the jury must make a determination of the questions in 5.1a and b, and then read with section 5.2 where applicable. So 10.1a drives you back to 5.2 where applicable, meaning that the court must determine how the deceased came by their death, and if it is necessary to do so to avoid a breach of a convention right, in what circumstances they came by their death. And it would appear that the reason why arguability is not the correct threshold at this stage of the process in relation to whether a relevant Article 2 substantive duty is owed is that it would not be a breach of a convention right not to make a determination in a case where a duty was only arguably owed. A breach of the convention right would only occur where the duty was actually owed. This may be important.
Well, is that right? If there were a procedural obligation, I mean, this is concerned with procedure, isn't it? And in section 5, let's bring it back up again. In section 5.2,
Yes.
One might have thought that it would be necessary for an investigation to ascertain in what circumstances the deceased came by his or her death, where, in order to avoid a breach of convention rights, where there was a procedural convention right. Rather, if you like, a procedural, when a convention imposed a procedural duty to investigate.
Yes, but it would only do so where the it would only appear to do so where the there had been an arguable breach of a convention right that had been established, rather than an arguable breach of an arguably existent convention right.
Right, and is there a Strasbourg authority for that?
And neither way round, so far as I can tell.
Right.
But you rely on necessary to avoid to say, in 5.2, to say it's only necessary to avoid a breach of the procedural obligation if that procedural obligation has arisen, and that is something that the coroner has to decide.
Yes. Yes, and when I say yes to rely, it's the point that I raise in an attempt to answer my Lord
Yes.
Stephen's question.
But but the procedural obligation must arise at a point before you can say that there actually has been a substantive breach.
Absolutely.
Otherwise, there'd be no point in having an investigation.
Yeah.
So, how certain do you have to be that there has been a substantive breach in order for the procedural obligation to arise, and hence
Only an
5.2.
arguable breach, but what I'm doing is atomizing the existence of the duty as against the arguable breach of it.
Yeah, I mean, I think we follow that you're doing that, but is it right to do that? I mean, when one looks at the Strasbourg and indeed the domestic cases, they talk about there being an arguable breach of the obligation, but doesn't that cover both, whether there is an obligation and whether it's been breached?
That's why I said, my Lord, that the cases tend to use a compendious phrase.
Yes, they do. So if they're using a compendious phrase, why doesn't it cover arguability as the existence of the obligation as well as arguability as to whether it's been breached?
Lord, I've said all that I wanted to on that in terms of reliance on the or pointing the court's attention to the words, the necessity of avoiding a breach of a convention right. I think that's as far as I can take it. In the
just on section 10, could I ask you one other thing which may be relevant to remedy? I don't know. This section 10.1 contemplates either the coroner, if there is no jury, or the jury, if there is one, must make a determination. What decides whether it's a coroner alone or with a jury? And the reason that I'm interested is, in terms of remedy here, would it be possible for it to go back to the coroner, who's heard all the evidence, just to give a determination himself? Now, if it turns out that it is, in fact, an Article 2 investigation, or does there have to be a full new inquest with a jury?
Answering that question in stages. The first part, what determines it? It's Section 7 of the 2009 Act, which you don't have, which contains a series of, well, it's split into two essentially, and sets out a series of mandatory grounds in which an inquest must be held with a jury. There is also a discretionary power for a coroner to summon a jury. I suspect I might be able to track down a reference to it elsewhere in the bundle.
Well, I don't want you to take up time on that. Can you say, are we dealing with a case where we're within the mandatory ground, so there has to be a jury? In this case, do you happen to know?
I think in this case, and this is very complicated, yes, because this was before the amendment of Section 48 of the 2009 Act. One of the compulsory grounds was where a person was in state detention. A compulsory ground for having an inquest with a jury was where a person was in state detention. That phrase had been interpreted as including those subject to a doles. Parliament intervened, and with effect from April 2017, amended Section 48 specifically to exclude doles from the meaning of state detention. I think I should probably show you that.
It might be helpful for us to know whether there are, well, what legal regime determines the situation now in relation to an inquest that was heard before. This inquest was heard. It
was held after the amendment.
Well, after the amendment.
In respect of a death.
Yes.
Well, the decision to hold the inquest was made with a jury was made before the amendment occurred.
Yes.
There must be some transitional provision.
Yes, there must be. Yeah.
I couldn't see one.
Oh, okay.
And is the duty made dependent on when the death occurred, or when the procedure began?
There's coroner's guidance on that, which I should turn up for you. So can I take that in stages?
Yes, definitely.
Just going back to the arguable breach of an arguable operational duty.
Yes.
It seems to have been argued, or one of the submissions at page 2160, letter G. But I, at present, can't find the answer to that. That's in Moran.
2160, my lord.
2160.
It's right next to the letter G in Roman 2. Arguable.
Yes. But at present, I haven't had an opportunity to find
a response to that by
see
the
what the
response
was. Yeah.
Can I go back to the questions then? Can we firstly start with section 7, the jury question? I've tracked down a version of it in the electronic bundle at page 2007. Do you have this in the judgment of Lady Justice Arden?
Yes.
Between letters B and D. This is section 7. You'll see the presumption in 7.1. The mandatory provision in 2. That's not a complete citation of the mandatory grounds, only those that were relevant to her ladyship. And then the discretionary ground in 3. We can, after the hearing, provide you with a complete version of section 7. I'm sorry about that. That's the best that I can do for the moment.
But I think you did tell us that you accept that we're dealing with a mandatory ground. That has to be a jury case, or did I misunderstand?
It was mandatory until the amendment.
Yes, I haven't thought about the position, to be frank, as to what the position would be now, were it necessary to hold another inquest. But perhaps we can see, look at the amendment that I mentioned. So you will see that one of the grounds for mandatory summoning of a jury in section 7 there is otherwise in state detention. It's that phrase that's important. And then section 48, the amendment, that's in 1924, please. You'll see in subsection 1 of 48, state detention has the meaning given by subsection 2, read with subsection 2, large a. Subsection 2, person in state detention if he is compulsorily detained by a public authority within the meaning of section 6. And then the amendment, a person is not in state detention when he or she is deprived of liberty under, and essentially they're the statutory provisions that permit for the issuance of a dole's authorisation.
So this is purely to do with whether you have a jury or not?
Yes.
Yes.
And then I said that I would take the court to the coroner's guidance.
Yeah, I mean, in fact, on section 7, it didn't seem that being in detention was a sufficient condition for mandatory jury. It's sort of detention and some other thing.
Plus,
yeah.
Yes, and there were 2 alternatives to the plus.
All right.
And then the coroner's guidance. If you turn, please, to 4091. And this is guidance by the Chief Coroner, number 16A, on doles from the 3rd of April 2017. That's the date that Section 178 of the Policing and Crime Act 2017 came into effect. That's the thing that amended Section 48 by adding, amongst other things, subsection 2A. You'll see that paragraph 5 sets out the questions for a coroner. And then section 7 suggests, sorry, paragraph 7 suggests that it applies in relation to deaths that occur on or after the 3rd of April 2017.
Right, I think that looks like the answer to the question I was asking, that the legal regime changes dependent on when the death occurs.
The death occurs rather than when the investigation commences. There's no cross-reference to why that is, but at the moment I don't seek to argue against it. Lord, I should just deal briefly in the time that's left to me at a practical level.
I'm so sorry. What, as I mentioned before, under Section 7, it's not enough that the death takes place in detention. There are other things as well. Do we have a ruling or some indication of the coroner's view as to whether one or other of the other conditions was satisfied? In other words, was he treating it as a mandatory jury case, or in fact was it in the exercise of his discretion?
Lord, can I turn my back on the court at the moment and ask? I'm not sure that I know the answer as disclosed by the papers. It was under the discretionary limb.
Right, so in other words, not determined that either of the two
conditions in Roman 1 and 2 was
so it was not a mandatory jury case, but a discretionary one.
Yes.
It's thought to be not mandatory.
Can I deal with the consequences of the issue before the court? The first is it would mean, of course, that a short-form conclusion would itself generally be insufficient to explain how Miss Maguire came by her death, if the appellant is correct. That's because it's common ground that Miss Maguire died of natural causes. But if it is necessary to ascertain in what circumstances she came by her death, then it would not be sufficient just to record those two words.
Are those options of natural causes, misadventure, or whatever, where are they set out?
They're set out in a note at the end of a form called Record of Inquest, which is annexed.
Statutory thing.
Yes, which is annexed to the Coroner's Inquest Rules 2013. I think the Lord Reed will be familiar with it.
Yes, I remember it all too well.
There's quite a lot of debate within the court and disagreement within the court over the status and meaning of a footnote to those rules in the case of Morn.
Yes.
I can give the court the reference to that if my lady requires.
Yeah, that's helpful.
So it is a statutory form of sorts. I should make it clear that this isn't always the case, i.e. if Article 2 requires how to be read as meaning in what circumstances, that a short form conclusion is insufficient. One can think of an example of a shooting by a police officer that results in a death, a case where an enhanced investigation is required automatically by Article 2 because a state agent has taken life. In many cases, a simple choice between a short-form conclusion of unlawful killing on the one hand or lawful killing on the other would allow the jury to express their conclusion on the central issue in the case. But in this case, more would be required. Natural causes wouldn't tell you enough to discharge the adjectival obligation. But we can see this reflected in, again, Chief Coroner's guidance. This is in note number 17. Can I invite the court to turn up 4099, please? One can see an expression of the alternatives in paragraph 9 on page 4101. A short form conclusion or a narrative conclusion, but it's permissible to combine them. And then guidance is given on page 4102 at paragraphs 15 and 16. This is general guidance at the moment, not concerned with Article 2 cases. Wherever possible, coroners should conclude with a short form conclusion. The short form conclusion should be one of those listed, and that's the reference, my lady, to the statutory instrument that I just mentioned. And then the guidance gives assistance on how to direct the jury on what to include in box 3 of the record of inquest, where a short form conclusion is left. The guidance then turns on page 4103 to narrative conclusions. At paragraph 21, as an alternative, the coroner or the jury may record a brief narrative conclusion in box 4. A narrative conclusion may also be used in addition to a short form conclusion. Paragraph 22 explains that where one is proposing to leave a narrative conclusion, how one deals with the fact that there is also a box 3 to be completed, and therefore the possibility of 2 narratives fall to be given, and gives guidance as to how to divide the narrative as between boxes 3 and 4. And paragraph 23 makes the point that narrative conclusions may be used in both Article 2 and non-Article 2 cases, and refers the reader to further guidance on Article 2 inquest below. And if we turn to that, to the below, that's on page 4104, starting at paragraph 32. This note, as I've just said, that in an Article 2 inquest, a short form conclusion may be sufficient to enable the jury to express their conclusion on the central issues. I gave the example of a police shooting. However, frequently a narrative conclusion will be required in order to satisfy the procedural requirement of Article 2. For example, a conclusion on the events leading up to their death or on relevant procedures connected with the death. So that's the first consequence of the decision of the court on the issue, namely whether a short form conclusion or verdict in old money would be sufficient to discharge the convention obligation. And in this case, answer no. Secondly, if it is necessary in order to avoid a breach of a convention right, to ascertain in what circumstances the deceased came by their death, through the use of such a narrative conclusion, then such a narrative conclusion may include a judgmental conclusion of a factual nature. It may therefore include judgmental language. And if you just cross-refer to our printed case, our written case, at page 65 of the key documents bundle. And at paragraph 11A, we give some examples of the type of language that a judgmental conclusion of a factual nature, which are, according to the Chief Coroner's guidance, permissible, inadequate, inappropriate, insufficient, lacking, unsuitable, unsatisfactory, and failure. That's to be contrasted with the prohibition on the use of any such language in a non-Article 2 case. One will see that if I give the court the reference, again, Sir Thomas Bingham in Jameson, electronic bundle 2051, side note F to G, and it's subparagraph 6 of his judgment. And then third, again, if it's necessary in order to avoid a breach of a convention right, for the wider question of in what circumstances the deceased came by their death to be answered, the coroner has a power but not a duty to leave matters to the jury that were possibly but not probably causative of death. This is the third consequence. One can see this in, if we go to the Chief Coroner's guidance at number 5, called the discretion of the coroner. Which is at 4076. And within that document, turn to paragraph 23, which is at 4079. So matters which are possibly causative but not probably causative of death may, but not must, be left to the jury to determine. Cross-reference there from footnote 28, the case of Lewis, in the court's bundle, is electronic bundle, page 2128 and 2129, paragraphs 28 and 29 of Lord Justice Sedley's judgment, with whom Lord Justice Reimer agreed.
Sorry, on...
Yes, it's 2128 and 2129. Paragraphs 28 and 29 of Lord Justice Sedley's judgment, with whom Lord Justice Reimer agreed.
Thank you.
That's the power but not duty to leave a very broad range of matters. It's a combination of those factors, narrative conclusions, judgmental language, and the permissibility of leaving possible causes rather than probable causes, that leads to juries being invited to express their views sometimes on a very wide range of issues, applying the very weak causation test of possibly causative. And the court will have seen what the Lord Chief Justice said in the recent case of Morahan at paragraph 7. That was the hand-up case that's not in the court's soft copy bundle, at paragraph 7 about that. Lord, I should just address, because there's no one else here to do so, the issue of the withdrawal of the concession by the appellant. The appellant, in her written case, and this is page 48 of the key documents bundle, in paragraph 50, page 28, paragraph 53A of the key documents bundle, that the operational duty under Article 2 was owed to Jackie by reason of the following circumstances.
Sorry, I'm sorry. This is
page 46, paragraph 53.
Yes, thank you.
The operational obligation was owed by reason of the following circumstances. A, B, and C are then set out. And then within A, 6 lines from the bottom, for the avoidance of doubt, the appellant submits that this circumstance alone, that's deprivation of liberty under a Dole's, is sufficient to give rise to a protective operational duty, and the concession is withdrawn. The way that the case was argued yesterday was not put on this basis, as it seemed to us. Instead, it was said in opening and in the course of the appellant's submissions that it was the aggregation of 1, deprivation of liberty, 2, assumption of responsibility, and 3, vulnerability that meant that the operational duty arose, rather than under 53A, the circumstance of the Dole's alone being sufficient to give rise to the operational duty. I should note, incidentally, that the way that the case is put here also, in some senses, reflected the case of the appellant. Initially, the existence of the 3 circumstances was said to be enough without more for the operational duty to arise, without any mention of the existence of a real and immediate threat to life being part of one of the essential building blocks to construct that duty. The appellant in her written case treated the real and immediate issue as relevant to breach, not to the existence of the duty. You can see that on paragraph 60 on page 51 of this document. However, we understood that the appellant accepted in argument that the existence of a real and immediate risk to life was a necessary ingredient to the owing of the operational duty. Now, in any event, because paragraph 53A of the appellant's case stands and hasn't been abandoned or explained, and because of the submissions of one of the interveners who adopts the same position, that's the UKSC, I ought to briefly address the issue of the concession. You'll have seen the concession recorded in the divisional court's judgment at EB, the electronic bundle 249, that's paragraph 47, which in turn takes you to the concession itself in the appellant's written reply in the lower court, which is electronic bundle 458 to 459, paragraph 5. And then in the Court of Appeal, the concession is recorded in paragraph 63 of the court's judgment.
Paragraph
63. As we see it, there are no issue of estoppel or cause of action, or estoppel or issue estoppel, or indeed abuse of process arises in what the appellant seeks to do here. And therefore one's forced back into the normal territory of withdrawal of concessions requiring the leave of the court. That being a matter of discretion for the court, it seemed to us that the factors might include the need for the court to seek to do justice to the parties based on a full and accurate exposition of the law and facts. But the reasons given for the attempt to withdraw the concession, I don't think there have been any. Whether the concession relates to an issue of law or fact, here this is an issue of law, not an evidential concession, so different treatment. And then lastly, and relatedly, whether any party has acted to their detriment. And it particularly applies ordinarily in evidential cases where you don't call or otherwise adduce evidence on the back of or in reliance on a concession. Here that issue doesn't appear to arise, albeit it might be said that others might have taken an more active role in the proceedings had they known the appellant's case is set out here, namely that the positive obligation under Article 2 applies without more if you're under a doles, applying to hundreds of thousands of people in the United Kingdom. Lord, I'm looking at the time.
Yes. Yes. Well, yes, I'm not quite sure you've only got a few minutes left. I'm not sure how you can usefully employ them. You haven't really reached your discussion of the authorities, have you?
No, well, I wasn't intending to do that
That's
exercise.
Fine. We've got your analysis on paper.
Yes. The only thing that
Can I just ask a question? Sorry. Is
Yes.
there any link between the existence of the Article 2 obligation and the requirement for there to be a jury in the inquest?
No. Whether in the statute or in the authorities. Some coroners some coroners approach the issue as if there is such a link, i.e. one equals the other. But I think that's rather a custom and practice issue rather than because of any principled basis.
You're speaking there of an operational duty, I think. You're speaking there, I think, of an operational duty.
Yes, although it could apply to the systemic duty as well, i.e.
Yes.
I think the question could apply, Lady Rose, it could apply equally to
yes, of course.
a case involving the systemic duty.
And did you want to say anything about the submission on remedy? And going back, if the inquest that has taken place so far was conducted as a jury inquest on a discretionary basis, if we decided that it should have been treated as an Article 2 inquest, would it be open to the coroner now to proceed, in effect, as a new inquest, but he's heard all the evidence, and give the relevant verdict under Section 5.2 himself without reconstituting a new jury and having the inquest all over again?
Yes, in the authorities that we haven't put them before you. Some lower courts, the divisional court in particular, have decided that the court, can write the narrative. I don't think that's a course that's open to this court.
But you're saying it would be open to the coroner?
Yes. I think relevant factors in deciding whether to adopt that course or to hold that there must be a new inquest would include the fact that it's been accepted by every party that the coroner's investigation was full, frank and fearless. Secondly, excuse me, there's no question but that the short form verdict conclusion that was recorded was the appropriate one, and therefore this isn't a question where there is a big issue on the appropriateness of the short form conclusion. So one isn't interfering with that.
So would it come to this, that your submission on remedy would be, if there has to be an Article 2, Section 5.2 verdict, that we simply quash the verdict that has been given already and remit the matter to the coroner, and then it would be for the coroner's discretion how to proceed in the light of that, rather than us actually ordering that there be a further jury inquest.
At the moment, I'm just trying to identify the factors that might tell one way or the other for the court in making that decision.
But what I was putting to you was that it rather sounds as though those would be the sort of factors that one might expect the coroner to take into account in the exercise of his discretion, if he has one. You tell us that he does. How to proceed in the light of us quashing the existing verdict? Or are you saying we should decide?
No, I'm saying that you should consider those.
So are you saying we should decide whether it's, if it goes back, it's coroner alone or jury?
Yes.
And as I understand it, that depends, because this is a pre-3rd of April 2017 death, that depends essentially on whether the legislation makes the holding of an Article 2 compliant inquest and therefore a jury inquest mandatory, or whether it's a discretionary.
Yes.
But I thought on that, I thought you told us that although being in detention is one of the preconditions for a mandatory jury trial,
yes,
that there are others, and that it was not determined by the coroners that the others were applicable. So, in fact, the bottom line was this was a discretionary jury trial case, not a mandatory one.
Yes.
But that was whether that decision by the coroner was correct or not.
It's correct or not
is another matter. Yes.
Yes, it's certainly the approach that he took that it wasn't a mandatory case.
But I thought you said that whether or not Article 2 applies doesn't affect the exercise of that discretion. Because you can have an Article 2 compliant inquest without it.
But I think it affects the discretion, but it doesn't determine it, which is why I understood the question that my lady asked.
I'm just wondering whether it wouldn't be better remedially for us simply to remit the matter to the coroner, so that these things can be argued out in more detail before him. Because, I mean, you haven't even shown us all the relevant provisions.
No.
It just seems a little bit difficult for us to make up our mind. And there may be arguments about whether, in fact, he should have found that it was a mandatory case.
Because of state detention plus.
Plus one of the others. I just don't know. You haven't even shown us the full text of Section 7.
No, it wasn't intending. I hadn't intended to address the issue of relief, and did so because my friend raised the issue this morning.
Yes. Yes, I suppose there might be an issue for us whether, regardless of the amendment in 2017, whether the words "in state detention," as they stood back in pre-2017, ought properly to be construed as including somebody who's subject to a Dole certificate.
That has been determined already by a court. Ferreira is the name of the case, and I can.
Ferreira decided that a person subject to deprivation of liberty was not
yes.
in state detention. Is that right? Is it that way around?
Yes, and the reference.
The finding in Ferreira was difficult. It's cases of one of those check ones. Remembers it right was that she wasn't deprived of her liberty.
She
wasn't in fact deprived of her liberty.
Yes.
So she couldn't conceivably be in state detention. So it dealt on the fact she was found not to be deprived of her liberty. There'd never been a Dole's authorisation, and the issue was whether on the fact she was deprived of her liberty.
So it doesn't actually decide that.
So it doesn't decide the point. No.
Right. Thank you.
That's 3601.
Right.
Thank you very much.
So that now irrelevant.
Well, the more we're hearing, the more attractive the option of remitting to the coroner.
I realise the longer that I speak, the more attractive it might become.
Yes.
Could I ask, Mr. Maguire went through very carefully all the evidence in this case, but as I understand it, the coroner never addressed or decided the issue as to whether there was a real and immediate risk to life.
That's right, and that's one of the reasons why you won't find me making submissions on a point-by-point reply to those, partly because those points were not made to the coroner. Mr. Maguire analysis is an after-the-event analysis by reference to the transcripts, and in any event, it's not the role of a judicial office holder to do so, to respond to them in that way.
Would it be appropriate for this court to make a decision about that issue if it was a necessary part of the reasoning, or would it be appropriate then to remit the matter to the coroner so that he could decide as to whether there was a real and immediate risk to life?
I think it would depend on the anterior building blocks of the court's reasoning as to which option fell to be taken.
My puzzlement coming out of that was, I thought the coroner had positively determined that this was not an Article 2 case. Are you saying he did that just because he read the previous decision of the Divisional Court and didn't go back to examine whether there was, on the facts of this case, a real and immediate risk to life?
The principal argument raised before the coroner was that Parkinson occupied the field and this case fell within either of the exceptions identified within Parkinson, namely of knowing conscious risk-taking or of systemic breaches. That's what the debate was about, and that was what the coroner's ruling was focused upon.
But isn't the first of those limbs the operative duty under Article 2? And doesn't that include appreciation of a real immediate risk to life?
No, because the way that the case was put to the coroner was that this was to be treated as, or much of the argument to the coroner was to the effect, as I've said, that Parkinson occupied the field, and therefore the question was about the applicability of the two exceptions to it, or identified within it.
Thank you.
So the answer is no, he didn't go through seriatim the breaches that have now been identified by others, including by Mr. Maguire.
He didn't. If the test for an operational duty in this case involves a determination as to whether there was a real and immediate risk to life, he didn't make that determination.
Correct. Well, I appreciate that's slightly unsatisfactory. It's partly a product of the time and partly a product of the function that I've been attempting to perform.
Yeah. Well, Mr. Beer, we appear to have run out of time. We're very grateful to you for your submissions. We're grateful to all counsel. Yes?
I was simply going to say that, had time permitted, there were a very short number of points I would have put, addressing some of the issues the court has asked, not repeating anything that was said earlier. I appreciate we have run out of time, and I'm not asking for the court's time now, yeah. But could I have the court's permission to put those in, add those to the note that we're going to send you in relation to the evidence? Yeah. They are solely points arising out of this morning and an answer to a question posted.
Yes, it seems that might be helpful. So if you could also give us those within 14 days.
Yes.
And if Mr. Beer has any points he wishes to make in response, then he has a similar period.
Yes. The day before Christmas Eve. The day before Christmas Eve.
Well,
I asked for the time of 14 days, knowing exactly when the day fell. So I'm taking a point against myself.
Right.
Yeah, yes, you'd already signed up to that time.
Yes. Yes, I made the suggestion.
Yeah. Yes. No, well, thank you. Well, we're grateful to all counsel for their submissions. This is obviously a case of importance not only for Miss Maguire's family, but it's of much wider public importance. You'll probably have gathered that we have the impression at the moment that the law is far from clear. It's our function to try to clarify the law where it is unclear. It's going to take us some time. I would imagine it will be some time in the new year before you receive our judgment. The court will adjourn.